Back on that note.
Thank you all. Please be seated. All right, call the case, please.
Good afternoon. The next matter before the court is Daniel Richard versus Daniel A. Goonan, Town Administrator, Town of Auburn et al. This is docket number 218-2022, CB 676. We are here for a preliminary hearing. If I could have counsel and parties introduce themselves for the record, please.
Yes, sir. My name is Daniel Richard. I'm here to defend myself, sir.
You're the plaintiff, so you're not defending anybody, right?
I'm sorry.
All right.
No, I'm representing myself in this matter.
All right. Thank you, Mr. Richard. And who's with you?
This is my assistant, Lynn Briggs. My assistant, Lynn Briggs.
Okay. Thank you very much. Just speak into the microphone, everybody, so that everybody can hear what you say.
Good afternoon, Your Honor. Miles Madison, appearing on behalf of the state.
I'm David Scanlon, Secretary of State.
Your Honor, Ann Edwards from the Attorney General's office.
Matthew Conlon with the Attorney General's office.
Michael Tierney for the Town of Auburn, and I have the Town of Auburn Town Administrator Daniel Goonan with me.
Okay, thank you. All right, just let me get my computer going here. Okay. I've had a chance to review what's been filed by everybody. Hold over just a second. All right, first thing is, Mr. Richard, I should tell you that for whatever reason, our file and serve software didn't accept your motion, and I found out about it when I read the objection this morning when I got here. So they actually sent it to us, and I had a chance to read it beforehand, which the attached CV of Mr. Is it Sayer?
Yes.
Mr. Sayer. So the first issue is, I'll hear you on your motion for to allow him to testify or present evidence from him.
Yes, sir.
And then I'll hear the objection from whoever wants to speak. Who's speaking on behalf of the other side?
I will be, Your Honor.
Okay, all right. Mr. Richard.
Your Honor, I have an answer to the objection.
Okay, why don't you just argue it to me? I'll take the notes.
Thank you, sir. Let's start here. The plaintiff failed to show, the defendants failed to show how they'd be harmed from such an expert testimony. Harm can only result from the plaintiff to the plaintiff and the public should qualified testimony not be permitted. The defendants already possess expert testimony in the third-party contractor, LHS, that the defendants have under contract. For the defendants now to claim that they need time to obtain an expert is conceding the plaintiff's case. This is the very argument the plaintiff is complaining about, the lack of qualified, approved technical support. The state of New Hampshire is maintaining electronic tabulation voting machines that are unsafe, unapproved, and not safety tested. In New Hampshire, the authority of having jurisdiction is under the state fire marshal in this case. It is dependent upon the defendant's expert when conducting field safety evaluations of electrical or electronic equipment. The defendants claim that this emergency is entirely the plaintiff's making. This is grossly inaccurate. The plaintiff filed a remonstrance and a notice of trespass with the defendants back in February of this year, complaining about the use of these voting machines and seeking a remedy. The plaintiff's remonstrance was filed in February of this year, and the safety hazard described in this complaint was just recently identified when presented to an expert and in turn expediently incorporated into this complaint. This is what constitutes this emergency hearing. The plaintiff is not seeking a delay or a cancellation of any election. Therefore, the defendants cannot claim any harm. The plaintiff can show no harmful remedy, the plaintiff can show a non-harmful remedy through the expert witness during the emergency hearing.
Okay.
Good afternoon, Your Honor. Just point out, as identified in our objection to the motion, emergency motion to present expert testimony today, that would be unusual and not permitted by the ordinary rules governing newly filed complaint that was filed days ago. We have, just as of 2 days ago, the notice that we received, the motion for, the emergency motion for expert witness testimony, and the issues raised as just admitted to newly identified. These are issues that are not properly brought before this court at this time in the form of expert testimony. We have a pending motion for a preliminary injunction that is before this court for consideration, and the expert testimony, the opportunity for examination, not only of the issue identified, but of the expert witness's credentials, the expert witness's report. There's a reason why the rules contemplate longer time periods, much longer time periods, on the order of months, for the consideration of those types of documents and that type of testimony. Use of that type of testimony on notice of 2 days is not proper. It's not contemplated by the rule. It's not appropriate in this circumstance, and the state objects to its use in the hearing on preliminary injunction here today.
Okay. So as I understand it, your objection is mostly based on the timing of the disclosure, and that at a permanent hearing, it may be admissible?
Your Honor, wouldn't speak to the admissibility at a later hearing at this point, but would identify that it is inappropriate under the rules for admission at today's hearing.
All right. I'll tell you what I'll do. Mr. Richard, I've actually read it all. So I read through his report, and I read through his CV, and I understand the arguments, and it's kind of related to your complaint. Normally at these proceedings, we proceed by offers of proof, and sometimes live testimony is required on key factual issues. I think but that we usually don't have experts disclosed a day or two beforehand, because I have to be fair to both sides. If they came in with an expert and you didn't know about it, you'd be objecting, and I have to protect everybody's fairness rights here. But I have read it, so what I'll do is I'll allow you to admit just for purposes of allowing you to substantiate your arguments here today for a preliminary injunction, admit the report and the CV, and I'll read through it, and I'll hear whatever the response they may have to it, and give it the way I think it is as a preliminary matter. Okay, so that way we don't have to cancel the hearing, because normally, if there weren't an election looming and the use of machines looming, I would say, well, I'm going to continue the hearing 2 weeks and let them respond to it. I would do the same thing for you if they did it to you. So I think that's a fair way to resolve this at this point, and that's consistent with the way we normally handle preliminary injunctions. Okay?
I understand, Your Honor.
Okay? So what I'll do is, I've already got a copy of it. I'll just have it uploaded as a court exhibit, so it'll become electronic, and I'll be able to access it. Okay?
Your Honor, my only comment to that would be, the Department of Safety doesn't want to hear a safety expert. And so whether it's today, tomorrow, or 10 weeks from now, it's going to be the same testimony. So
I understand. No, I understand. It's just the timing of it, though. They have to have a reasonable opportunity to respond, to look at the CV, consult with whoever's at either the Fire Marshal's office or the OSHA department or whatever agency you preference. I can't remember, so there's an alphabet soup of agencies you put in your motion, so I couldn't remember all of them. But at least give them a meaningful opportunity to respond to it. Okay?
Sir.
Okay. All right, so that's what I'm going to do. So the objection is sustained in part, overruled in part. And if the state wants to submit, I'll hold off on a decision for a couple of days. If you find that you want to submit something in the next couple of days, I'll take a look at it. Okay? So proceed, sir.
I'd like to bring forward a few witnesses that are relevant to this case.
Okay. Who do you want to call?
The first witness I'd like to call is Tom Murry, and Tom Murray is a local New Hampshire resident who is intimately involved with SB 43 and the Linden audit. He's going to substantiate some things that are relevant to the expert testimony that takes it from to make that case for him.
Okay. Well, I mean, how many witnesses do you plan on calling?
3.
3? Okay.
Not counting Mr. Say, I have 3 witnesses.
Okay, and how long for each witness?
Only a few minutes per, and we'll have a few questions for each of them.
Okay, I'll allow the testimony. Go ahead. Where is he? Sir?
Mr. Murray?
Mr. Murray, come on up. stand is right here, it's kind of well hidden. So raise your right hand, you swear the testimony you're about to give this court will be the truth, the whole truth, and nothing but the truth under the penalty of perjury. I do. Please have a seat, state your full name for the record. Right there, sir. Yep, come around the room. There you go. Thank you.
Thomas J. Murry Jr. of Wyndham, New Hampshire.
Where do you live, and how long do you live there?
I live in Wyndham, New Hampshire. I've lived there for approximately 21 years.
What's your interest in this case?
My interest in this case is to make sure that these machines that are being used in our current elections are being accurate, reliable, and they're not causing any harm to the public.
Thank you. The reason I asked you to testify is because I learned that you witnessed certain testing on AccuVote voting systems. Am I correct in saying that?
That is correct.
The forensic audit report, page 7, items 1 and 2. Item number 2 in the forensic, on page 7, forensic electronic investigation of memory cards and machines. Number 1, we verified that the telephone modems had been removed and that all the cables connecting to the external ports had been cut or removed. Did you witness that statement?
I did not witness the cutting of the modem cables, no, sir.
Or did you see the fact that they have been cut?
I did see that they have been cut, yes, sir.
Thank you. Number 2, EEPROM chips were removed from the motherboard and forensic images of the contents were made. These were compared with forensic images of the contents of EEPROM from the reference machine of the Secretary of State. Did you witness that?
I did, sir.
Thank you. Who did you witness working on the machines during your time with the audit?
The auditor, Harry Hersey.
Do you know if such a person, excuse me, is there any video on him working or anyone else touching or working on these machines?
Yes, that video is on the Attorney General's webpage.
Thank you. Excuse me, did the person working on the machines use what's called electrostatic discharge protection?
The person, the individual that worked on the EEPROM, to remove the EEPROM, he had a wristband, however, it was not properly grounded.
Thank you.
You need him to stay back from the mic a little bit.
Can I have him verify these photos?
So you can hand them to you, much, or we'll mark them as exhibits then.
You don't have copies.
Did you give copies to the other side?
I don't have copies today. but-
Okay, why don't you show them? Rules of court require you to show the other side, and they have to show you.
This is all part of SB3, and that's where these pictures come from. They come right out of their own.
They come out of the Wyndham audit report?
Yes, exactly. Because that's what I have here. This is the SB3 forensic audit report. That's where these pictures are.
It's before.
There's the chips. Yes. Yes.
Murray, do you have to watch
No, I wanted us to go to Tom to verify that he did.
We're going to put the stickers on them first,
Perfect.
okay?
You want each other?
Yes.
That way the record knows what exhibits you're showing.
Thank you. Can you explain to the court what that is?
Yes, that is a memory card for the AccuVote OS machine that's currently used in the state of New Hampshire.
Thank you.
That is an AccuVote OS machine, again, currently used in all throughout the state of New Hampshire. And that is also the plastic ballot box that the machine goes into.
Can you speak up?
Certainly. That is an image that was taken by Mr. Hersey. That was the AccuVote OS machine that is in the open position, so you can see the internal components. including the area where the memory card is inserted, the EEPROMs, the NEC 8088 chip, and the printing mechanism along with the dialog. And you can also see in this picture where the modem wires are cut, as well as the ribbon has also been cut. This is a picture from the SB43 audit of the NEC 8088 chip, which is the chip that is used in the ActiveVote Dialog AVOS machine, along with its EEPROM. And this is multiple pictures, again showing the connections where the wires have been cut, the ribbon has been cut, and you can see where the EEPROMs have been removed as well. You want to show them to me?
I'm sorry. I'm worried, I'm sorry.
It's all right, lawyers forget that step too. Okay, thank you. Yeah, one of the-
And those are all, just for the record, all those photos are on page 97 in the state's forensic audit. SB43.
Those are all listed for page 27.
And
Hold on for a second. Yes, I gotta mute. For some reason, the open mic on the internet here. All right. Whenever someone calls in late, they don't get muted. I'm sorry about that. Go ahead.
That's all right, thank you, sir. Those are the only questions I had from Mr. Murray.
Okay. Cross-examination.
Good afternoon, sir. Just one question for you. During the course of the Wyndham audit you were referencing, you attended that
I
audit?
did up in Pembroke, yes, sir.
During any point of that audit, during any examination or operation of any ActiveVote ballot counting device, did any of those ever explode?
Did any of the machines explode?
Yes.
I did not witness any of the machines explode, no, sir.
Anything based on that, sir?
Yes, just because the machine didn't explode, does that mean it won't explode? Can you certify, can you testify that these devices are safe?
Objection, Your Honor. This is to call under speculation. It's not an expert witness, more than an expert witness to speak to the operation of all devices.
Well, I'll ask them questions. It's more of a rhetorical question, I think, but.
It is.
Go ahead. If you know the answer.
I'm sorry, can you repeat the question again?
Yes, is it from your study of these machines, do you think that this is, the fact that the machine didn't blow up at the audit is an indication that it's somehow safe?
No, my background is a civil engineer and also a contractor. I very frequently work with UL listed devices and appliances, and I can clearly see that this appliance has been modified, the ribbon's been cut, the electronics have been manipulated. Would I classify that, in my opinion, again, I'm not an expert testimony, but in my layman's opinion, is this a safe device? No, it is not.
Thank you.
All right. Sir, you may sit down.
Thank you, sir.
Thank you.
Croc TV.